is a set of there's a code section 16.7.201 and following, and that covers ADR in general. But there are a couple of specific statutes in there that you should really be very much be aware of. And the first one is that the courts in Arkansas, pursuant to 16.7.202, have the authority, the circuit and district, the circuit and appellate courts. District court is specifically excluded in this statute. The circuit and appellate courts have the authority to order any civil, probate, domestic relations, or juvenile mediation, case to mediation. So any case out of the circuit court, with the exception of cases out of the criminal division, can be ordered to mediation. If the case is ordered to mediation, then the parties are required to choose a mediator from the commission's roster of mediators that meet our requirements for that type of case. So when we get into talking specifically about certification, there are 4 categories of certification: civil, probate, domestic relations, and juvenile, and we'll talk about those. If the parties want to use someone who is not certified by the commission, they have to ask the court permission to do that. And if the court grants them permission, then they can use someone who's not certified. And there are mediators in the state who mediate and are not certified. And I'm not making any sort of judgment about whether they're a good mediator or a bad mediator just because they don't have certification. And I know of several instances where mediators from out of state have come in and mediated. In one instance, it was like copyright infringement sort of stuff. And that was this mediator's particular area of specialty, was trademark and copyright and all of that sort of stuff. And so they brought someone in specialized to do it. So sorry if you can hear my cat. He's really loud. He's very loud. He wants in the room. So the other thing to know, just for those of you that are practitioners as lawyers, if you didn't already know this, this statute says that on motion of all parties, the court must make an order and stay the proceedings. So if both parties motion for the court to go to mediation, the court is required to enter an order for mediation and stay the case. I would use that judiciously, but it's a possibility. As attorneys, 16.7.204 says that attorneys are encouraged to advise their clients about dispute resolution processes and to help them select which procedure that is appropriate. And that may be just litigation, but as attorneys, we are supposed to advise our clients about the myriad of options that are available to them. And the most important one that you're going to want to be very familiar with is 16.7.206, which is the confidentiality statute. Mediation is a confidential process. Any of you that have sat in a mediation representing clients have probably heard the mediator talk about mediation and mediator confidentiality. And one of the reasons it's really important, one of the reasons we do this course is because initially we didn't, and we had issues with mediators coming back, getting trained in other states. Other states have completely different confidentiality laws. They have completely different processes. Some states require mediators to make a report to the court and a recommendation. Arkansas, if you did that, you would get in significant trouble because you're specifically prohibited from making recommendations to the court if you were the mediator in the case. So this is a statute that says that mediation is confidential, that records and writings are confidential that are made in the the mediation. And it doesn't matter whether it's before proceedings begin or after they've started, it's just confidential. And that here's the interesting thing that I think is going to get tested, and you should very much be aware of this. We almost had an answer on it, but then the parties withdrew their case. It says that Section B, it says the participants or third party or parties facilitating the process, that means the mediator, shall not be required to testify in any proceedings related to or arising out of the matter in dispute or the subject process, or be subject to process requiring disclosure or production of information or data relating to or arising out of the dispute resolution process. So you as the mediator should not be subpoenaed to come and testify about what happened at that mediation. The reason I say that is going to be tested, because I'm sure some of you are familiar with it. There is a case on the books now, Smythe. And in Smythe, the Court of Appeals, I think you have Smythe in your materials. In Smythe, the Court of Appeals said that the court should have a hearing. They reversed the court and remanded them that the court should have a hearing to determine what was mediated at the mediation. I think they were referencing subject matter, like what subjects were mediated. They did not say in Smythe who was supposed to testify to prove that. But what happened was one party subpoenaed the mediator, and the mediator filed a motion to quash that subpoena, citing this statute. And the court denied that motion and was going to require the mediator to testify at the hearing. The mediator took it up to the Supreme Court, and the Supreme Court accepted it and was going to make a ruling on it. And then it became moot because the parties reached some sort of agreement and withdrew the action. That's it in a nutshell. But that was all behind the scenes. Right now, what's on the books is Smythe versus Smythe. And it does say that courts can have hearings to determine what issues were mediated. It just doesn't say who has to testify or who can. I think the judge made a mistake in that issue. I think this statute is fairly clear, but I'm also not a judge. And so what I think really doesn't matter. So just be aware that that's in play. We've had another couple of cases come down recently, one of them pertaining specifically to mediated settlement agreements and confidentiality around those. And that also went the other direction. In that case, they said no, the confidential mediation agreement could be brought in and basically made it not confidential. So just be aware that we have some issues around confidentiality that have come up in our upper courts in the past couple of years. And you need to be aware that that's impacting, because up to this point, we really have not had any case law. It's just been this statute. And so we're now starting to see more case law. I think we will probably see more. I think we're probably going to, especially in light of the Smythe case, I think we're going to see more instances where people are trying to drag mediators into the courts to testify around issues. So just be aware of that. The last thing there is 16.7.207 makes mediators immune. So they have immunity. No impartial third party administering or participating in a dispute resolution process shall be held liable for civil damages for any statement or decision made in connection with or arising out of the dispute resolution process, unless that person acted in a willful or in a manner exhibiting willful or wanton misconduct. I've never seen anything on this in Arkansas All the mediators I know have insurance. It's usually a rider that's attached to their, if they're practicing attorney, it's usually attached to that insurance that they have, their malpractice insurance. I suggest it's not expensive, and we always suggest that all mediators take out malpractice insurance, because that's the bar, but you can still be sued. So, and you'd still have to defend it. So that's all the law that pertains to, well, there's one other code section, 912-322, and it talks about how courts can order, they can either order mediation around custody visitation, or they can send the parties to parenting classes. And I think most courts do both, frankly, but the statute says it's an or proposition. So that's really the statutes that we work with. The way, for those of you who are out there practicing, you're probably familiar with what's happening in your area. If there's court-ordered mediation taking place, it is different all over the state. What is experiencing in Lone Oak may be a little different than what Hadley is experiencing in Rogers. Hadley is in a high mediation area of the state. There are several mediators up there who do pretty good practice, I would say, and there are some judges on the bench in both 19 West and 4th, and really 19 East, who order mediation quite a bit. There are other areas of the state where not so much, but something to think about is we're about to have 30 some odd new judges on the bench. We have 125, we're going to have 125 circuit court judges come January, and over 30 of them are going to be new on the bench. That is a massive turnover of the judiciary all at one time. And so they will be going through new judge orientation like all new judges do, and they'll be, told they can order. I've already had judges contact me about it. I've had judges contact me about our grants to talk about, like, oh, could I set up a mediation program? So some of them are interested. Some of them down in South Arkansas, where there's almost no mediation taking place, probably aren't going to be very interested in mediation. There's just not a culture for it in South Arkansas. So there are, well, maybe one of them, because she was a certified mediator and she mediated quite a lot. So maybe that one new judge will shake things up down there a little bit, but on the whole, not so much in that area of the state. Usually an order goes out, and this is what you need to be aware of with orders. You, the mediator, will not be given a copy of the order typically, because you're not a party to the case. So you're not a lawyer on the case. Typically, the court does not send the mediator a copy of the order. When you take your case in, when they hire you, I strongly suggest you ask, is it court ordered? And if it's court ordered, you ask for a copy of the order for two reasons. One, as a mediator, a certified mediator, you're required to fill out a statistical reporting form on every single court-ordered mediation that you do. You're going to need the information off of the case styling. You're going to need all of that to fill out that statistical reporting form. The second reason is that sometimes judges put in their orders that the mediator is supposed to report back to the court within 10 days or whatever their time frame is at the conclusion of the mediation. And they're doing that for docket management reasons. Sometimes they require the lawyers to do it. Sometimes they ask the mediator to do it. You, the mediator, pursuant to the ethical rules for certified mediators that we're going to talk about, you can make a report that says three things and only three things. That the case mediated or the case did not mediate. Pick your poison. Who attended the mediation, and the case settled or the case did not settle. The number one reason we have disciplined mediators is for reports to the court. It's the number one. Mediators communicating with the court about a case beyond the bounds of those three things. And on our website, under our forms section, we have created a form that is the mediator's report to the court. And at the top of it, it has the ethical rule that mediators have to abide by, not for the mediator, but so that the judges see that there's an ethical rule that limits what mediators are permitted to share with the court. And so, and also, if you use the form, it's a checkbox, fill in the blank form. It's kind of hard to go afoul of the rule if you just use that form. So it's there, but you could also do a letter. And the letter could say, "Dear Judge, pursuant to your order, this case mediated on," even say the date, "on this date," because they want to know that. They frequently want to know if they're trying to manage their dockets. So-and-so and so-and-so attended. No agreement was reached. Sincerely. We had a mediator send a letter to the court that said, no agreement was reached because the plaintiff was unwilling to accept reasonable settlement offers. I'm sorry, you now have to try this case. Sincerely, mediator. I'm sure you can guess who sent in the complaint. Like, the plaintiff's lawyer sent in the complaint to the commission. They were furious about that because then the judge got on them. So, period, end of sentence after no agreement was reached or an agreement was reached. We've also had a mediator go into the details of an agreement was reached, blah, 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 kind of talking about what the agreement was. We've also had a mediator send one in that said an agreement was reached. I don't really think that mom's lawyer really liked it very much. This case may need additional mediation in the future. I'm sorry, that's beyond the bounds of the rule. Like, just don't communicate with the court about the case other than those three permissible things. And the court will push you. Some courts put in their orders that the mediator will report back to the court whether the parties participated in good faith. The rule does not allow you. Now, Smythe does talk about good faith, and in fact, it said that that was part of what the hearing was going to be about, whether or not the parties participated in good faith.
Hey, Jennifer.
Yes, ma'am.
As it happens, I was the ad litem in Smythe. And so although I was not a part of the mediation, one of the things that I think interesting about that case is that there were so many attempts to mediate because lawyers were on one side of the fence, lawyers were changing sort of constantly, right? One of the parties sort of kept hiring new attorneys. So then there would be mediation scheduled with this attorney, then it wouldn't occur. Then there would be mediation scheduled with the next attorney, then it wouldn't occur. And so I think the judge's frustration resulted in what ultimately I agree was not the correct application of the law for sure. But I thought that in a family law setting, the circumstances were different because we had all of these changing lawyers. And so it was, I think there were probably 7 attempts to mediate in the background, of all of that other stuff happening until the big mediation did occur. And when I say big, it wasn't actually big based on what came out of it. But anyway, just thought I would throw that out there, that I think that muddied the water for a lot of attorneys because there were a lot of cooks in the kitchen trying to discuss what was happening at mediation with the court,
Yeah, and also on the back end, after Smythe came out, it took them a long time to find a mediator that would take that case. No mediator. Like, I had mediators calling me left and right going, I just got a phone call. They wanted me to mediate that case. I'm not touching that case. No one wanted to be involved in that case because everyone knew that the mediator had been subpoenaed. And they were like, and what the Court of Appeals said, and they were like, we don't want to touch that with a 10-foot pole. And then I forget who did it, but they called me and they were like, oh my God, I had no idea what was going on. And I agreed to do this. And now I'm in the middle of it. And I'm like, oh, you know?
Yeah, and the mediator went to a great expense, obviously, in hiring their own attorney and doing all of that, and got no money for any of their attorney's fees.
Oh, yeah,
Yeah.
yes, yes. So it was a situation, and those situations usually do make for bad law, I think. Like, and it was pretty clear, just, I got on Court Connect and just went through and it was pretty clear that there was a lot of frustration happening behind the scenes that triggered all of that. But now we're stuck with SMI, which is kind of not the way I wish that had come down. And I really respect the 3 judges that were on that panel a lot. And so I just kind of thought, oh, wonder what happened there. But okay, so just be aware that reports to the court are a big issue, and some judges want the mediator to report back good faith. And I'll just tell you, the track most mediators have done is they just send in their report and they don't address that subject, with the assumption being made that they would, like, oh, everybody participated in good faith because I'm not telling you someone participated in bad faith. And most of the time that's fine. Judges just leave it alone. They assume if you're not telling on someone that everything went well. But we've had some judges push for that. That one of those judges is about to retire from the bench, though. So I have had a question about, do you report to the court only when the court order says we need to? You're not required to make a report to the court. You can. That is optional. If the court asks you for a report, you need to file a report with the court. But if you just want to, as a matter of course, or if you want to check in with the lawyers, hey, do you guys want me to just send this form to the court so they know you've been here? That's absolutely fine too. It's a discretionary thing for you. Now, remember, as I mentioned statistical reporting forms. I believe there's one in your packet. And remember that if it is a court-ordered case, at the conclusion, you've also got to fill out that statistical reporting form and send that into our office. We don't track mediators. We don't really, it's not like we're trying to figure out what you guys are doing. We're trying to track where mediation is taking place in the state and what kind of cases are being mediated. It really helps us develop like judicial education programs and things like that. And when a judge calls and says, hey, like, how many cases have I ordered this year? We can say, well, we can give you a rough estimate because people are self-reporting, so we know we're not getting accurate numbers. We know that those are not true statistics. It's more of a sampling of what's going on. So don't forget to do your statistical reporting form. It is in your packet of materials. I think Jim is probably not going to be able to hop on. I know he had a mediation this morning. So let's just talk a little bit about the ethical rules. And our ethical rules are in a document called Requirements for the Conduct of Mediation and Mediators. And they're not long compared to our ethical rules for attorneys. It's a walk in the park to read them. When you apply for certification, you're going to have to sign a form saying that you have read these rules, that you understand them, and that you agree to abide by them. I just want to hit a couple of highlights on these rules and talk about a few disciplinary complaints that we've had against mediators, and then the disciplinary process. So one of the biggest one is, well, it's not one of the, you would not think that it would be. It's in the overview, standard 3, the mediation process. It tells you what should be in your mediator's opening. It also says, and this is really important, that the mediator does not represent either party and will not give professional advice. That is addressed elsewhere as well. You may be a professional counselor, you may be a lawyer, you may be a CPA. I don't care what your professional background is. And the parties know that. The parties just want what they want, and they're gonna try to get information or advice from you. And so you have to be very diligent about that. And for those of us that are attorneys, especially when there are pro se clients involved, it can get very challenging because we can know the law and we can know what they're wanting to do is problematic, but we can't advise them of that. So you have to be very careful to stay on the side of providing legal information, like a general information and overview, but you can't apply it to their particular case, no matter what you know. Obviously, when lawyers are involved, that takes that pressure off sometimes, depending on, I guess, how good the lawyers are. Because sometimes the lawyers just aren't up to date on whatever it is. There may be a case that's come out, or they really don't understand the calculations for the new child support guidelines or whatever it is. So you may find yourself having a conversation with the lawyers to get on the same page about that, but you can't give that advice to the clients. We have, in fact, had a complaint filed against a mediator about that very thing. Let's see. Be aware that there is in that same standard 3 under B, continuing mediation, at the very end of B, that it says if one or more of the parties is unable or unwilling to participate in the mediation process in a meaningful manner, except in multi-party disputes in which the parties who are willing and able to participate may reach an agreement or may reach a resolution. We had an instance, and we added that language about multi-party because in civil cases, there are frequently multiple defendants. That's something that you see. But this was a domestic relations dispute in which the grandparents had established visitation rights. The grandparents had actually been the guardians of the children at various times in the history of this particular case. So mom and dad were there mediating because dad currently had custody of the children. Grandparents had visitation. Mom wanted to alter that and have more visitation, have her visitation had been supervised or something. But nonetheless, the mom and dad agreed on one thing for certain, and that was they both hated the grandparents. And so and grandparents were very, very disruptive, I will say that. And the mediator kicked the grandparents out of the mediation and then continued to mediate between mom and dad. And mom and dad reached an agreement in which grandparents got no visitation. And then they took that to the court, and the court entered that as an order. Well, there are a host of issues there, really, and I think there was issues on the court side about what happened. But the issue with the mediation, which is the only thing that we had any control over, was, and the grandparents filed a complaint against the mediator for kicking them out of the mediation and not letting them participate because they were a party to that case. You can't do that. You can continue to mediate if one of the parties said, I'm done, I'm out of here. And other parties want to stay and remain and try to work some things out. But you can't eject a party who is a party to that litigation from the mediation and then continue to mediate. So just be careful because people will be disruptive, but you can't, you have to end the mediation if that's the case. You cannot continue. You can't throw them out and then continue the mediation. Let's see. Another big one is, as we've talked about, just reports to the court, and that is standard 7. And it says that they're not allowed except, and it tells you the permitted ones. Professional advice, this says, and I think this is an important delineation. The rule says a mediator shall not provide information which he or she is not qualified by training or experience to provide. So you can provide general information, but you can't, as we all know, provide legal advice. And it says, Part B of that says, when a mediator believes a party does not understand or appreciate how a potential agreement reached through the mediation process may adversely affect the party's legal rights or obligations, the mediator shall advise the participants to seek independent legal advice. So you cannot give legal advice. And if you think they don't understand it, you are obligated to tell them that they should go seek legal advice. They don't have to follow your advice, but you are required to give it. Another thing that you don't want to do, and I know that there are mediators who do this, particularly I see it more in civil cases. Under professional advice D, standard 8D, personal or professional advice, a mediator may discuss possible outcomes of a dispute, but a mediator shall not offer a personal or professional opinion regarding the likely outcome of the likelihood of any specific outcome. And I know mediators, especially in the civil arena, do get pretty close to that if they don't cross it. So yeah, you can say, here's some possible outcomes, but you can't tell them this is probably what's going to happen. You don't need to as a mediator, you don't want to put yourself in that position anyway, because they're going to potentially detrimentally rely on you and take that as advice. I'm sure you've all seen it. You do want to talk about, and it's helpful if there are lawyers there, it's okay to talk about how a judge usually rules, especially when it's the lawyers, talking about it. And you can use the lawyers to get that information out on the table, because that does impact the parties' thinking on the decisions they're making. Advertising, there's really no issue there. You can advertise. I have had an attorney call and ask if they could charge contingent fees. They wanted to set up, they were trying to, I don't know what they were trying to do, I guess pull in more business, and like, well, could I do mediation on a contingency fee? That if they don't reach an agreement, they don't have to pay me, or whatever it is. No, you cannot. The rule specifically says that mediators shall not charge or accept a contingent fee or a base fee in any manner on the outcome of the mediation process. So you can't make your fee permanent on the outcome of the mediation process. So there's a whole section in standard 9 that addresses fees. And you're supposed to do that. And I think everyone does, because everyone wants to get paid. You do that on the front end when they call you. And I think everybody does that. I think it probably goes without saying. So conflicts of interest are another one. And for people who work in law firms, that can be a little bit trickier, because maybe that firm or someone else in the firm has handled something, or maybe even something related to this dispute, or in small towns where there aren't as many lawyers, you may have represented this person in a different case involving something else. You got to under the rules, it's okay. You can mediate that if you've represented them before, because it's not the same case, as long as it's not the same case. But you have to disclose that to the other parties, because that's a potential conflict of interest, that you had this past relationship with this person. So you have to be, and those of you that are lawyers have to be really careful about conflicts of interest anyway. So it's really not anything that would be unfamiliar to you. But it can be tricky because it's a small state. And it can come down to people changing we had one instance where everybody was there. The mediator walked into the room and realized that the person sitting at the table was one of their best friends from high school, under a married name that she did not recognize. And the other person was like, no, I do not want you mediating this for me. And so weird things come up all the time. Just be aware of that. And I don't want to harp on it too much, because I think you really just have to read these. I will tell you, as I mentioned, reports to the court have been our biggest thing. Be careful for those of you that have multiple professional backgrounds. Lisa, for you, it probably won't come up as much for you because your professional background has been an educator. And that is less tricky than when you are, say, a therapist and a mediator, or a lawyer and a mediator. Be careful about how you market yourself, because for lay people, it's confusing. They don't understand. And we had an instance where the person was a lawyer and a mediator, and that was on all their stationery. They didn't separate out their two businesses in any way. They kind of just used one letterhead for both, and it said licensed attorney, certified mediator. Well, they had a pro se client. It was not their client, as a matter of fact. What happened was they were hired to be a lawyer, and the other party was pro se. And the husband said to the wife who was pro se, you need to come to this address at this time. We're going to mediate. He used the word mediate. Wife shows up, and they are in fact there to see, because the hearing is coming up, and she's representing herself. Is there anything that we can work out here today prior to the hearing? But the lawyer was there as the lawyer. There was no mediation taking place, but the husband had used the term mediate, and that was what was on that stationery, and that's what that wife thought was happening, and that the lawyer was being a mediator. And so when they showed up for their hearing, by that point in time, she had gotten herself a lawyer, and she said, oh, his lawyer was our mediator. And then the lawyer said, that's a problem. You need to report that. That's an ethical violation. But it took us forever to pull that case apart and figure out. And the lawyer was able to document, like, look, here's all this stuff I sent to her, as an attorney. It was clear that I was acting as an attorney, but it's not clear to lay people who don't. Why would it be? Like, if you're not in this professional realm, and why would you not conflate? Why can't you be both? They don't understand that you can't serve both roles at the same time. And so just be really careful, because it can get dangerous, particularly when pro se clients are involved. So this is really more of an issue for people who work in the domestic relations arena than it is for people in the civil arena, because you very rarely see civil litigants who are representing themselves. It's just not as common. So as far as I'm hopping along. Can you tell that to the lawyer outside of the hearing of the participants? Tell what, Kelsey?
I'm sorry, I didn't know if I could just interrupt and ask the question.
I should have said, y'all unmute yourself. I'd rather have a conversation than a lecture, so just unmute and ask whatever.
Okay, I've been in mediations where the mediators, it's been helpful when the mediators say, no judge is going to go for what you're wanting. You need to agree. And it sounds like to me that is not okay. My question is whether you could say as a mediator, if the party's represented, look, Bob, Judge so-and-so is known for making, this type of order. He's not going to go for what your client's asking for. Let's get real. And I feel like mediators add value when they force the parties to understand reality. So, but based on what you were saying, it sounds like you can't give an opinion about the chances of an outcome.
I would be careful about it. I agree with you that it does add value because parties, they can't make an informed decision unless they know how much risk, right? Mm-hmm. I think that's part of it. Like, you want them to understand this is what this judge does most of the time, but you can't tell them like that's what's going to happen because you don't know that 100%. And you don't want, that's why I'm saying it's a lot easier when lawyers are there, because it's different when they have a lawyer representing them, because then they're really relying on the lawyer's advice.
Right.
It gets a lot trickier when there are not lawyers there and when you're dealing with a pro se person, because then when you start telling them that stuff, they're relying on you. Do you see what I mean? There's a difference, I think, when lawyers are involved, because the lawyer could totally disagree with you and say, that's not how. And so I think there's a difference when you have lawyers involved and when you don't. I think when you don't have lawyers involved, you still have to raise the risk, but you kind of have to do it a little more carefully. Does that make sense?
It does. I just wonder where the line is, because even with my own clients that can be persnickety, it's nice to have a mediator come in and tell them how unreasonable my own clients are being. They hear it from another person, but I guess I will dig in and
well, and they can just agree. I mean, like my experience when I'm out representing clients is the same as what Kelsey is telling you. I mean, in my experience, I've had a similar experience to her. So what your lawyer is telling you is good, sound advice, So, and my job as a mediator is to point out how much, so that you can make an informed decision here, like how much risk you have, so that if you don't reach an agreement here, that's the risk you're taking. I think you can do it. You just have to be really careful about it, particularly when there are not lawyers there.
I don't know if I would mediate for pro se litigants.
Well, it does get very tricky.
Yeah.
So if there is a complaint, here's the complaint process. I get complaints. People tell me stuff all the time, verbally. That means nothing. Like, people can grumble all they want to grumble. But it's not a complaint until it is put in writing and submitted to me in my capacity as basically executive director for the commission. So until they put it in writing and submit it to me, it's not a complaint. That's how you begin a formal complaint against a mediator. The person filing the complaint should not be in contact, because once they are in contact with that commission member is now not going to be able to sit and hear that case. So we keep a wall between the commission and the investigation. So the complaint triggers an investigation. I'm on that investigation committee, and we'll have, of the 7 commission members, 2 of them, we rotate through, 2 of them will be pulled over to help investigate the complaint, leaving 5 remaining commission members to sit as the hearing body. And so we will also pull in any necessary staff members. So let's say it's a complaint around an access and visitation case, which is one of our programs, I would probably pull Stephanie Smith in to assist with that because she runs the program. So then we make a determination whether or not it violates any of the rules or requirements. And if we do, we notify the commission that we need to have a hearing. And we schedule it. It's like scheduling any hearing. And we have to have a court reporter there, and we have an attorney at the AG's office who will basically bring the case against the mediator. At that point, those of us that were on the investigation committee are really out of it. You know, and as far as we don't bring, none of us, I mean, it doesn't matter that we're all lawyers, we don't act as the lawyer and bring the case against the mediator. An attorney for the AG does that. The mediator can have their own lawyer, they can represent themselves, they can have whoever they want there with them, but it is an administrative hearing. And we follow all the rules for administrative hearings. And then the commission makes it, those 5 remaining commissioners make a determination about whether or not the mediator violated any rules, and they can sanction them up into from as low as a caution up until stripping them of their certification. And they write a written opinion, and that comes down. If the mediator wants to appeal that, it's like any other appeal from a regulatory body. They appeal it de novo to circuit court, but the circuit court only looks at whether or not we followed our own rules. And if we followed our own rules, the discipline will stand. The court doesn't go, oh no, that shouldn't have been a suspension, it should have been a reprimand. They won't do that. That's not how that works. They just determine whether we followed our own rules. So that's our disciplinary process. Again, we have a set of rules that walks you through it, and there's a complaint form, so that if you're ever out there and you see something really egregious and you need to file a complaint, the rules are there, and there's a form that you can fill out. I haven't had a complaint against a mediator in a very, 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 very long time. And I like to think that's because mediators are out there functioning in an ethical and professional manner. I hope that's what's happening. I don't know what's going on out there, but we just haven't, which is one of the reasons our CME that we offer, which I'll talk about in just a minute, we've been offering to our mediators for no cost, because part of renewal fees and application fees and all of that goes to, we have to keep it in a fund to cover administrative hearings. And because we haven't had to do that, we use that money for education. So it benefits, we just basically give you your money back in a way. What was the next thing on my list? Okay, let's move to, so far, do you guys have any questions? I'm really moving pretty quickly through this stuff, but it's not overly complicated material here. Okay. Let's talk about the certification process itself. We regularly, we will receive applications and we will package them back up and mail them back to the applicant because they are incomplete or because there is a problem with them. And so that's why I like to walk through the process with people so that you don't make that same mistake. So I hope that you've looked at the certification requirements. There are rules. I've told you there are 4 categories. Generally, no matter what the category, there are 4 basic standards. You have to meet educational standards, you have to meet training standards, you have to meet practical experience standards, and you have to meet ethical standards. For training, for education, if you have a master's degree or higher across the board, you can be certified, or a Juris Doctorate or equivalent. You meet the educational standard for every single, all 4 categories. In domestic relations, you can get your certification with a bachelor's degree if you have 2 years work experience in family and marriage issues. And I will say that is almost impossible to do, because most people who have work experience in family and marriage issues are counselors, social workers, something in that nature, and they all have master's degrees. So I think there's only been one instance where that has been granted, and it was someone who was in clergy, and for years, many, many years, what they had done was work with families who are divorcing. And so they could document that and demonstrate their work, and the commission makes that decision, staff does not. If you meet all the objective criteria, the commission never sees your application. The staff processes it. If there is some sort of discretionary decision that needs to be made about your application, like work experience counting, then that goes to the full commission. They review your application and they make a determination. So if you have a master's degree or a JD, you can check the box all the way across the board, you're good. For training, which some of you are going to do, some of you have just completed, some of you are doing it again. Your training has to be, as you know, with a training course that is approved by the commission. That is not an issue here. All of you have done that or are about to do that. You've all smartly contacted our office to make sure you were going to one that worked. If you want to be certified in civil, you have to take a 40-hour basic or civil mediation training course. If you are going and taking a 40-hour family mediation training course, we will accept that. So you can check that box. For domestic relations, if you take a 40-hour basic or civil, you then have to take a 20-hour family. Or you can just go and take one 40-hour family mediation training course, which I think is what most of you are doing, because that's what Missouri does. The reason being is, in domestic relations cases, we want you to have some training on domestic abuse. We want you to have some training on calculating child support, and it's just a different arena, and there's some specialty things. Maybe talking a little bit about quadros, things that come up when you are doing domestic relations work, dissolving a marriage, splitting assets, dividing up children. Family dynamics is another part of that. So that's why you have to have the family mediation piece of it. Here's where everybody screws up. Practical experience. This is where we see over and over and over again people making mistakes. And that is, they will go out and you have to do 2 observations, co-mediations, or mediations. So it can be, the sun is shifting on me. It can be any combination of those: observation, co-mediation, or mediation. Some people go out and go back to their community and say, hey, I feel confident in this. I want to mediate a couple of cases, and I'll do it pro bono. I'll do a couple of cases free because I'm trying to get my certification. So that's what some people do. A lot of people go and observe a mediator mediate a domestic relations case. So are all of you really focusing on that domestic relations piece, or are you also focusing on civil? So Lisa, did you say both? Okay. So here's the thing, the 2 hangups. Number 1, when you go and observe a mediator or co-mediate with a mediator, they need to be certified in the state of Arkansas. If you go and observe someone and they're not certified, that's great experience but it is not going to count toward your getting your certification. So make sure they are a mediator who is certified. We have had to send applications back because they've observed someone who wasn't. It also has to be an Arkansas case. It has to be in the circuit courts in Arkansas. That's what we are certifying you to do, is work in our circuit courts in Arkansas. So great that you observed a case in Texas or in Oklahoma or in Missouri, but if it's a Missouri case, it's not going to count here. It has to be a case that either is filed in the circuit courts of the state of Arkansas or would be filed in the circuit courts in the state of Arkansas. So if you're getting a domestic relations certification, if that's what you're wanting, you need to observe 2 domestic relations cases. And this is another area where we see the mistakes. Someone will go and observe 1 civil case and 1 domestic relations case and send their application into us, and they don't meet anything. So if you want to be certified in both civil and domestic relations, that means you have to go and observe 2 civil cases and 2 domestic relations cases. And you need to make sure that your mediator is certified. Certified in both civil and domestic relations, you're going to have to do 4 observations: 2 civil, 2 domestic relations. For probate, there are no freestanding standards. If you meet the requirements for civil or you meet the requirements for domestic relations and you check the probate box on your application, we will certify you in the probate area as well. If you do not check the box on your application, we will not certify you in that category because you have not requested to be certified. So people sometimes call and are a little frustrated with us because they're not showing up on the probate list, and we pull their application and they have not checked the box. That indicates to us that you don't want to do probate cases. So just be aware that's an area of great confusion. The observation piece seems to be a piece that causes great confusion for people. If you decide you want to be certified in juvenile, that's a lot more difficult because you have to have a specialized training called Juvenile Court Overview for Mediators. We are the only ones that offer it. We haven't offered it in about 3 years now because there are no longer funds to pay for juvenile mediations, which means there aren't really juvenile mediations happening, which means there's no way for you to get your practical experience. And so it's kind of like, sure, we can give you the training, but then there's no way for you to satisfy, it's very difficult to satisfy the practical experience component. If juvenile mediation is something you want to do, then you need to call our office and we can walk through and have a conversation about maybe how to go about doing that. Judge Smith in Benton County just actually last week was awarded a grant from us. He requested some money so that he could do some juvenile mediations in his court. So he has his own little pool of money that to pay for those. So there is clearly going to be at least a little bit of juvenile mediation taking place in that area of the state. So, do you guys have any questions so far about the certification process? Okay, there is a checklist that we have created on the front of that just to help people. Because we have to have a certified transcript, not a copy of your transcript, and not your diploma taken off your wall and copied on, like, that's not, I mean, we used to get we got a lot of those. I don't care about your grades. We will take a certified letter from the college or university as well. We also just need your last degree. Like if you have a JD, we know you got a bachelor's. You know, like if you have a master's, we know, just give us your last one. If you're an attorney, you don't even have to provide us a transcript, because we go in and we check and see if you're licensed in the state of Arkansas. If you're a licensed attorney in the state of Arkansas, we go in, we can see, oh, licensed in the state of Arkansas. We know that OPP has already verified all of this. We know this person has a Juris Doctorate or equivalent. Done. So for lawyers, you don't even have to mess with the transcript piece of it. If you're from a different professional background, then you do have to provide us with a transcript or a certified letter, a certified transcript or a certified letter.
So Jennifer, I'm sorry, Jennifer.
Yeah.
I was just wondering that, so if I'm an attorney that is, so I have my license practice and with another state, then you would just need my transcript from law school?
That, or we could see if you're a licensed attorney. But usually you have to give us some sort of permission, like an authorization form for us to contact that licensing entity. A lot of licensing entities won't give people from out of state information. We've run into that in the past. So you can give us an authorization form and we can get proof from that state that you're licensed attorney there. Then that's another way to go about doing that.
Okay.
Anything about certification? Yes. Kelsey knows about this because Kelsey said, I did my training in law school. I think Melissa said something the same way, and time passed and now their training is stale. It's like they didn't take it. From the minute you finish your training, the last day of whatever day is on your certificate that they give you, the clock starts running and you have 3 years to get a complete and accurate, we're not going to mail it back to you, like it's all put together application into our office. So time passes, as we all know, a lot more quickly than we think it does. And that 3 years will fly by in nothing flat. So I advise you to go ahead and get on getting your certification and not putting it aside. If you're interested in multiple areas of certification, get one, just get one. Don't worry about trying to get everything at one time before you submit your application. If you can get your 2 civil observations, get them done, get that application into us, we will certify you as a civil mediator and the clock stops. And then you can just update your status. You don't have to apply again to us. So then let's say you go out and you do your 2 domestic relations observations. Mail those in with a letter that says, I would like to update my certification status and be certified in domestic relations. And we will update you and you will become certified in domestic relations. You don't have to pay fees. You don't have to fill out more applications. Once you're certified, we can update your status and the areas in which you're certified from that point forward. So just, you know, it can help expedite things for you and stop that clock from running out on you. And I think that's another thing that confuses people. They think, oh, I have to do it all at one time. And you don't have to do it all at one time. There's a $75 application fee with your application. Let me tell you about the reporting period. So the reporting period is not the same for those of, I know I keep harping on lawyers, but we have a reporting period that begins July 1 and ends June 30. That's not the case for mediators. The reporting period for mediators is September 1 through August 31st. And we do rolling certification. So we accept certification applications every day, working day of the year, and we process them every working day of the year. So there aren't periods of time where it's open that you can get it. So be thoughtful about that and understand, if you get your certification, let's say you get your training, you'll get it done by the end of the year, you're certified in January. Great. That means you're going to, in the summer, you're going to be like, what's going on? Because you're going to get a renewal packet. Because you have to renew your certification before August 31st. And you have to pay a $75 renewal fee. So just know you're going to have, let's say, 9 months of certification instead of a full year before you have to renew your certification. So just be aware of that. Another thing to be aware of is you get a grace period. All certified mediators are required to do 6 hours of continuing mediation education every reporting period. So that means, but your first reporting period that you're certified, you get a waiver, a grace period. So let's say you guys get certified in January, you do have to renew by August 31st, but you have 0 hours of continuing ed due by that time. Starting September 1, the clock starts ticking on you, and you have to do 6 hours of continuing ed before the following August 31st. Does that make sense? Okay. You can go ahead and do 6 hours of continuing education, even though you don't need it, because you can always carry over 1 year. So you can always be ahead 1 year. So if you do continuing education in your grace period, you'll get credit for it and it will carry over. So just be aware of that. For continuing education, it has to be approved by us. It doesn't have to be offered by us. So there are all kinds of continuing education programs that are happening, and they don't always get submitted to us for approval. So if you see something out there and you're like, oh, I really want to do that, shoot me an email, send me the information so that I can look at it and I can approve. And I'm the one that approves CME. So I say this counts or it doesn't count. So even if it's not on our list, if it's something you want to do, you can ask, I can approve it, and you're good to go. We also offer continuing ed. Next year, we're doing, pre-pandemic, we did what was called regionals, where we put together a 6-hour program, and we did it 5 times in 5 different locations of the state: Northwest, Northeast, Southwest, Southeast, Central. So we took it out to everyone. Now, post-pandemic, everything we've allowed now, things more online things to count, and we're going to do a webinar every month through July. So January, February, March, April, May, June, July, there'll be a webinar every month. So you can get your 6 hours from us, doing an hour every month, or you can go and do it somewhere else. It does not matter as long as it's approved CME. So that's CME. I'm trying to think if there was anything else I need to cover on certification. Do you guys have any questions about certification? Make sense? Okay.
I have one question.
Yeah.
Do you have a list, or is there some place where we can go to get information about mediators who are willing to let people observe, or is that just something we have to just start reaching out to mediators and see if they'll let us observe? Like if we're not familiar with the whole mediation process, or people, is there a way to find people who are willing to let us mediate or observe?
No, there's not a list of people who allow observations. Technically, any certified mediator who is out there mediating could allow people to observe. There are people who are more proactive about it than other people, and they tend to be the busiest mediators, so they have a lot of cases. What area are you interested in getting your certification?
I'm probably going to do both the domestic and civil.
So for domestic relations, we run a mediation program out of our office. It's called the Access and Visitation Mediation Program. It is a statewide mediation program. You can call Stephanie Smith, or better, email Stephanie Smith at stephanie.smith@arcourts.gov, and let her know that you need to get 2 observations, and she can put you on a list. Because we pay for those mediations, we put in a clause that, like, by agreeing to mediate work for us and by agreeing to participate in this and have us pay for it for you, you may have, and we don't call them observers. We don't call you observers. We call you like a mediator trainee, or like we make it clear that you're kind of like a resident at the hospital. You're not there to watch them. Like, observer sounds weird. Nobody wants an observer in their mediation. So that is one way to get your domestic relations. If you know people in your area that are, doing a lot of them, get in touch with them quickly, because that will be a much faster process. That being said, sometimes it's just not, it's too much for a mediator. Like, it's a case that, like, no, this one is going to be just hard enough for me to try to mediate. And if one of our mediators says, not for this case, then we're not going to have an observer in that case. We really leave it to our mediators to say whether or not they can handle it in that particular case. So in that instance, yes, there's a place where you can go to get on a list. For civil, ask around who's really doing a lot of mediation in your area, because that's the best way. Find out who's doing mediation, the most mediations. So Jim Tilley, who is on our commission, he mediates all over the state. He is busy, busy, busy. He's also really proactive about allowing people to observe him. He's very proactive. JP James is in Searcy. He's also very good about letting people observe his mediations. So there are people in the state who are doing a lot, and those guys do civil work, not domestic relations. There are people, the busier people tend to be the people who will let you in. But it's hard because you're just juggling a lot of schedules. Your schedule, mediator's schedule, then the mediator has to get permission from the lawyers to have someone extra in the room. When you're paying for mediator services and you don't want someone in the room, they shouldn't be in the room. So that can be the toughest part of getting your certification, is getting your observations. So that's very long-winded answer to your question, but I'm sorry, it is tough, and it is.
Thank you.
So,
thank you.
Okay. Trying to think if I've missed anything. I've tried to move through really quickly. Let's see if we initially seek her. Yes. Okay. So I've answered your question, I think, Melissa, about, all you need to do is provide us the verification of observation forms. In the application packet, there's a form. So how do you prove that you've done your observation? We want external documentation. So there's an easy little form. Just print it out, take it with you. The mediator will complete it. Literally, it's, again, just fill in the blank, sign your name kind of form. You get the form back from the mediator. Do not send the form to our office. Do not have the mediator send the form to our office. We do not keep up with random observation forms. Keep it. It goes in your application packet all together. And so that is an easy way for you to prove that you've observed. If you mediate a case, you can give us a copy of your agreement to mediate, the signed agreement to mediate. Or you can have one of the lawyers just do a quick memo that says, Hadley mediated a domestic relations case for me on this date. That's all it has to say. But we just need some kind of external verification that you have mediated that case or observed that case. And that's all that that involves.
I have a question about that.
Yeah.
When you say mediated, if I'm in a mediation representing a party and I'm not the mediator or an observer, does that count?
No.
So how could she
Everybody
be,
likes that.
in your example, how could Hadley mediate if she's not the mediator?
No, I'm saying if Hadley were the mediator in the case, like
Okay.
Hadley could send me a copy of her agreement to mediate with the party's signatures, her document, like
Okay.
that she uses as the mediator, or she could have one of the lawyers send a memo, do a little memo saying Hadley mediated this case for us on.
Okay.
But when you're the lawyer in the case, you're not seeing the entire case. You're not observing the entire case. You're only seeing part of the case. And so we want you to go in and observe through the eyes of the mediator, not through the eyes of an advocate. So that's the purpose of that. So I meant Hadley was acting as the mediator, not acting as the ad item or the lawyer. Sorry about that confusion.
No,
This
Jennifer,
may
can I
be,
further clarify that? So what you're saying is, even though we're not certified as mediators, there's nothing to prohibit us from acting as mediators. So we
exactly
could just
what Melissa said.
mediate. Okay. So and is that's true for any of the domestic relations or the civil?
That's absolutely true. Now go back to the statute. If it's a private voluntary case, they have decided to go to mediation on their own. If you just decide to go to mediation, Melissa, you're representing a client and y'all decide, you know what, we're going to take this case to mediation. We think it's the best option. There's not a court order. You can hire Joe Bob the mechanic to mediate the case if you want to. You can hire anybody you want.
And so if I do that, then that counts as an observation / mediation, even though I'm not certified. Okay. I just wanted to clarify.
But if it's court ordered and you're not certified, they need to let the court know they're using a non-certified mediator, and the court has to say, okie dokie, you can do that.
Good deal. Thank you.
No problem. George, you had a question?
that was my question, just how to be a mediator if I wasn't certified. So you answered that. Thank you.
Yeah, certification is not like licensure. We have to have our license to be a dentist or to be a nurse or to be whatever it is, but certification is limited for the specific purpose of being eligible to mediate court-ordered cases. That's all it's limited to. So you can go out there and mediate to your heart's content for non-court-ordered mediations without certification. So, and like I said, I know there are mediators out there mediating without certification, and that's fine. There's nothing bad about that, no rule against it. But what it means is if the court is going to force someone to go to mediation, you want them to meet, at least have some basic qualifications, and more importantly, have to follow ethical rules and have a recourse for a person to be able to file a complaint. If you use a person who is not certified, you have no recourse. You can't file a complaint with us. We have no jurisdiction over them. So if you use a mediator that's not certified, they're not obligated to follow, they're not required to follow the ethical rules. They're bound by the statutes, of course, but not the ethical rules. And you don't have any recourse to file a complaint against them with us. So I think if you guys don't have any questions, I really tried to hustle through this morning. I apologize for the late start. I'm going to go over court structure, which the majority of you don't need. And that will only take just a very few minutes. I just want you to understand sort of, it's very rudimentary, but it's helpful to understand how things are set up here and how our judicial circuits are set up and all of that sort of stuff. It's always interesting, but you all, the majority of you are out there working in that system and are very well acquainted with it. So if you don't have any other questions, we can end here. And if you guys think of something, you can always email. I'm sorry, the light is awful, like it's shifting on me. You can always email or call, and I'm happy to answer any questions about certification of the rules or whatever it is. We're always available. So, but anyone who needs to stick around for or wants to stick around for the talk about court structure, you can do that, and the rest of you can have a wonderful rest of your day.
I have a quick question that's self-serving.
What?
I have a quick question that may be self-serving. CLE, is this for, do I need to turn this in for CLE credit under, not mediation credit, but for legal education?
Yes, I'm pretty sure that's a Stephanie Copeland. I'm about 100% sure that she applied for CLE credit.
Okay.
And
Sorry, yes, I did. And I just sent, just a reminder to everybody to send me their CLE forms. They should be attached to that packet.
Okay. All right.
Yeah.
Cool.
Mm-hmm.
Thank you so much.
you would fill out the CLE form and then send it in to Stephanie.
Yes,
so that
I
we
did.
can certify it and then we'll turn it into OPP.
Got it. I found
But
it.
yeah,
All right.
you will get CLE credit.
Yes.
Thank you.
Okay, so we put in 1 hour for ethics and then the half an hour or so for general.
Yeah. Yes.
Okay. Thank you.
You're welcome. If you need more CLE credit, you can stay on for court
I'm hanging
structure.
in there.
Most people don't need CLE credit. Okay. I look forward to seeing you guys later, hopefully in person at some point. Hadley will be in touch later on as we prepare for your, and if you're certified by then, you'll get enhanced CME credit starting at right out of the gate. So you're just on it.
Thank you.
All right, so let me pull up this court structure piece. All the wonderful documents that okay. All right, I am going to share my screen. Let's see how this works, just so you can see the document that I'm talking about. So can you all see this document? Are you seeing me or are you seeing the document? Oh, I can't hear you, George.
I see the document.
Okay, great. Okay, so this is the Arkansas court structure. So I don't like this view because I cannot see everyone, but I'm just going to talk through it. Okay, so I remember when we weren't structured this way, when we had chancery and circuit courts. But in 2000, there was an amendment to our state constitution that completely reworked our court system. And out of that, we have a 3-tiered system. And in other states, and George, if you've practiced in other states, or if you went to law school in another state that had a lot of, it can get confusing because people use the term district courts in different ways. In a lot of states, the district court is the equivalent of our circuit court, just the terminology. But here in Arkansas, district courts are the lowest tier of, I hate to say it that way, the lowest tier of courts. You can see on this, we have 2 different kinds, and local district courts, and you can see what they let's zoom in because I'm too blind to see this. What they handle small claims matters. That's anything 5,000 or below. And in small claims matters, they can't have attorneys the parties can't be represented by attorneys. And then they have a 5,000 civil jurisdiction thing. Eventually, we won't have local district courts anymore. Over time in Arkansas, all courts are being converted to state district courts. Also, most local district courts, it is a part-time judge. So that judge would be a practicing attorney and a district court judge. It is their part-time position. So it's minor civil matters. A lot of evictions and things like this also take place in district court. There's not a court reporter in district court. And if you want to appeal anything from the district court, it gets appealed to our circuit courts and it is tried de novo, which means all over again. Basically, it's tried as though it weren't tried below. So that's the appeals process from district to circuit. State district courts, which is what we're moving to on the whole over a period of time, all of our district courts will be state district courts. You can see they have a $25,000 civil jurisdiction matter. You do have lawyers involved, lawyers can be involved in those. Small claims and misdemeanor, traffic, that sort of thing gets handled there. If you're arrested, you're going to get passed to circuit court from there. I used to do that a lot. When I did criminal law, you would go in and depending on the charges, misdemeanor gets handled at district court. And then if it should be at the circuit court level, the district court passes it up to circuit court and it becomes a circuit court case. So felony charges, that sort of thing would get passed up. None of these district courts, while there may be mediation programs attached to some of them and mediation takes place, there is a referral process. It's if you want to go to mediation, we have this program available for you. You can go and mediate. There are very few district court mediation programs, but there are some. We have one in Pulaski County. There's one in Bentonville. There was one in Searcy for the long. And we just in Franklin and Johnson County, the new district court judge there is starting a mediation program. So from district court, we don't have court-ordered mediations. As a certified mediator, you're not going to be necessarily working in these courts. If your local judge has a program or wants to establish a program and you want to work in that program, you're welcome to, but you don't have to be certified to do that. Once you move up to the circuit courts, that number 123 is increasing. We had new judgeships created and that takes effect on January 1. All of our judges are elected and at every single level, as you all have seen. If you weren't aware of that, if you're new to Arkansas, you know it now because it's election season. And the signs have been up everywhere. And there's our 5 divisions: criminal, domestic relations, civil, probate, and juvenile. And a circuit court judge has jurisdiction to hear all of those. But in each circuit, and I'll talk about circuits in a minute, in each circuit, let's say there are 5 judges in a circuit. They will come up with an administrative plan and they will divide up who is doing what. So in some circuits, all judges, they'll divide it up, hear all types of cases. In some circuits, you'll have judges that will hear exclusively juvenile cases. And they're the judges that hear juvenile cases, that's all they hear, and the other judges don't hear juvenile cases. Or maybe you have a judge that hears only criminal. And a certain number of years, they have to review and can change their administrative plans. So it just really depends on the circuit and every circuit is different. We do have a few circuits in this state where there is only one judge. It is a one judge circuit. That means that judge is the one judge that hears 100% of all 5 divisions, if that makes any sense. And then appeals from our circuit court go up usually to the Court of Appeals. They hear the bulk of things. Our Supreme Court hears very specific types of cases, death penalty issues. It's enumerated what they hear. They do have the power, though, if there's a case that has been filed with the Court of Appeals, because that's the appropriate court where it should have been filed to appeal from the circuit court, and they want that case, they can actually reach over and take that case away from the Court of Appeals and hear it themselves if they determine that it's of a matter of such importance that they should be the one making a ruling on it. Because there are sometimes instances where if something were going to be appealed from the Court of Appeals, it's going to go to our Supreme Court. So that's a very rudimentary explanation of our court system, but I think it's pretty simple and clear. And where our certified mediators are working is in our circuit court system. So that's where we're focused. Let me see if I can open the judicial circuit maps. Where to go? There's, okay, I just saw it and now I don't see it. Just a second. It will be easier if I do it this way. There we go. I'm going to share again. Okay, here's our circuit map. And we are broken into 28 judicial circuits in this state. As you can see, if you look up in the northwest corner of the state here, you'll see 19 West and 19 East. Once upon a time, that was just the 19th Judicial Circuit. But for whatever reason, and there are various reasons why circuits get broken in half, it was divided into 2 circuits. And so now 19 West and 19 East are 2 completely different circuits. 19 West is Bentonville, Rogers, Springdale. This is Eureka Springs, Berryville are the 2 biggest towns over there. Where Kelsey is the 14th. So, and there are a different number of judges. So there are a lot more judges in the 4th, in 19 West, in the 6th. We have a lot of judges here in the 6th. And the 20th actually has a lot of judges. If you're in, I think it's the 12th, they have 1 judge. We actually 19 East has 1 judge. So there are several districts or circuits in our state that have only 1 judge. If you're in Pulaski County, your judges are not going to travel. They're called circuit judges because they used to ride the circuit. They used to travel. That's why we still have that terminology. If you're in Pulaski County, our judges have their own designated courtrooms and they are not traveling. Like, they're in Pulaski County. You come to the Pulaski County Courthouse. If you're in the 2nd Judicial Circuit over here, these judges travel constantly. So they are all moving around in all of the counties and going to every single one of the courthouses. And they have an entire schedule that they print out every year where you can look and see which judge will be in which courthouse on what day. So I say this to illustrate that number one, when you're looking at the court order and you see the 20th Judicial Circuit, this is what it means. It's these counties and it's the judges who work in there. And so it's going to be, you know, Judge Clausen or Judge Troy. Oh, his name just flew right out of my head, who does a lot of criminal. You've got a number of judges there and that's where they're going to be. But each judicial circuit or each area of the state has its own sort of set of normative legal practices. And so if you're practicing in Bentonville, let me tell you, it is extraordinarily different than practicing in El Dorado, which is down here, or way different than practicing over, say, in St. Francis County over here. The number of lawyers is different. The socioeconomic status is different. The legal traditions are different. The way judges do things is different. It's just, so knowing those things and kind of familiarizing yourself with, if you're going to practice statewide, it's important to know those things. This was, I had a thought. It flew right out of my head. Well, I'm sorry, the thought has escaped my brain and it will come back to me at some point. Okay, I'm gonna stop sharing. So it's, Lisa, do you have any questions? Does this make sense? Do you have any questions so far?
No, it's very straightforward.
Okay, yeah, I'm trying to make it just as clear cut as it can possibly be.
Yeah, I appreciate it. It's fun.
Well, and Kelsey knows this. I also, like, even when I'm talking to my law students, because I teach at the law school in Fayetteville and, well, in Little Rock too. When I want to talk a minute about the circuits, the divisions of our circuit court. So remember, there's criminal, civil, probate, domestic relations, and juvenile, those 5 divisions in our circuit court system. And I want to talk a little bit about what does that mean? Like, I keep saying those words, but what does that mean? Criminal is pretty obvious, right? Like, people know what a criminal case is. You've committed a crime, you've been arrested. Now you're gonna, you know, have a trial about it. Civil, let's talk about when I say, oh, this is a case out of the civil division. What does that mean? Well, that could mean any number of things, but examples are, if you're in a car wreck and you're injured, you have a personal injury case, that's in the civil division. If you are suing someone for wrongful death because, you know, tragically something has happened and someone's died and you think it's the fault of someone else and it's not a criminal matter, that's going to be in the civil division. If you have a property boundary dispute with your neighbor, that's going to be in the civil division. So those kinds of cases are non-criminal matters, go to the civil division unless they meet certain sort of other specifics. So that would be, let's say, probate. Probate, everybody sort of is, the obvious one is wills. And if there is what we call a will contest, or if the family is disagreeing on how that will should be, property should be distributed, or whether the will was valid or not. That happens in probate. Guardianships also happen in probate. So if we need to, if my mother-in-law gets to the point where she's mentally incapacitated and she needs someone to take care of her, we would go to the probate court to request to become her guardian. So adult guardianships are done there. Adoptions are done there. So there are some civil matters that are done specifically in that probate division. The domestic relations division, which is an area that everyone in this group is very interested in, handles the dissolution of marriage and the issues around that. So the granting of the divorce, the division of the marital property, any kind of spousal support that would be established, child custody of the minor children, child support for the minor children, visitation schedules, and even if you're not married, once paternity is established, those things would be handled in the domestic relations division. Juvenile matters, when we say the juvenile division, there are 3 kinds of cases in our Arkansas juvenile courts, and that is, one is delinquency. So minor criminal cases, when minors commit crimes, they go to the juvenile division of our circuit court system, and that is called a delinquency case. In certain instances, obviously minors can be charged as adults, and then that would be in the adult criminal division. But when minors commit crimes, in general, delinquency cases. So delinquency is one kind of case. There's another kind of case called dependency neglect, and that is when there are allegations of abuse or neglect against the child, and the state removes them from their parents, and then that is a dependency neglect case, and the state has to, generally the goal is hopefully reunification. And there's a whole case, the whole case is about the parents getting themselves together. So if you've got, often drugs are involved, not always, but often drugs are involved. So if you've got a parent who is drug addicted and not caring for their child, or something like that, the hope would be that you could get that parent the services that they need so they could go into, sobriety and be in a position to take care of their child. That may not be the case, and then you would move to terminate that parent's rights, and that child would then be up for adoption, which there's a whole level of conversation that we could have about this system. It's very complicated, but I'm just trying to keep it in simple strokes. And then there's a third kind of case called family in need of services. As an educator, you're probably very familiar with FINS cases, because the bulk of FINS cases are truancy cases. But a FINS case is typically not necessarily where the parents have done something to the child. It is some sort of issue with the child's behavior, and they can become dependency neglect cases, because once you open the FINS case, well, the kid may not be coming to school because, mom is a meth addict and is not getting the kids up and getting them to school or feeding them, or there might not be electricity in that. So it could become a dependency neglect case. But frequently what triggers a FINS petition is truancy at school. So that's just one example, but I'm sure you're very familiar with all the different ways that can come into play. So those are what the kinds of cases that get handled. So if you say you want to do civil and you want to do domestic relations, when you talk about domestic relations, those are the things. Dividing property, and custody, visitation, and child support of children are the big ones. Kelsey, that's the area in which you're practicing. Do you have any input on that?
I actually do 0 domestic relations work.
Really? Oh,
I'm happy about that.
Good for you.
Thanks. We do have lawyers here in our firm that do it. I stay away from it though.
Okay.
But I agree with your assessment.
So you're doing civil.
Yes. I'll probably go ahead and get the domestic relations certification if a case comes up that I could be of use to someone. All the attorneys here, we all know each other, and it may be something that, hey, I've got a case that'll be something that we need a mediator quickly. That way I could help, but it won't be my focus.
Yeah.
That's my intention. Who knows what the future will hold.
So as a practitioner here in Arkansas, do you have any other feedback that you think would be helpful to them on like our court structure and what they should know? I just
Right.
try to keep it very simple.
I would say that most judges are, I feel like there's a trend towards mediation, that the newer judges are less likely to, or more likely to order mediation and not be, I don't know the right word to use, and this video is recorded, so maybe I shouldn't opine, but I think the trend will be towards mediation, and the judges are less intimidating. The newer ones are less intimidating and controlling over their courtrooms, and they want to get cases settled quickly, I think, anyway, at least in our area, and to not be hesitant to ask for help. One question I had, if we are to enter a report, and this is a practical matter, are mediators able to do that through eFlex, or is it manually provided?
That is a good question, and it's never been posed, and I need to ask Tim Holtoff about that. My understanding is that it's been done manually.
Okay. All right, probably just through email to the trial court assistant or something.
Right.
Okay. But yeah, I think there's a big need for it, and it's only going to grow.
Well, and I couldn't agree with you more. I mean, people have been saying that a long time, and it has grown. I don't think people realize, because people grumble, oh, there's just not enough mediation business. Well, there are a lot more mediators than there used to be, and they are mediating. I mean, there was a time period where there were 3 mediators in this state, and they did all the civil work. Like it's just a really different makeup of things, and I think there's room for people to come in. And here's another thing to consider that bodes well for you, and we just had a conversation about this at the last commission meeting, that we need to be encouraging, let's say, younger or newer mediators to come in, because a lot of the mediators who are big active practitioners are getting to a point where they're ready to retire. And we've already had several mediators who were very, very, they did a lot of mediation. I mean, they were mediating every single day, retire, just completely retire. And so we do you always need new people to come in to fill, you're always going to have the people leaving the profession and people coming in, and that's what you want. I think the pandemic is going to have a profound impact on mediation, because with the courts being shut down to the extent that they have been shut down, and the fact that there are not a lot of civil trials being held, period.
Right.
And even criminal trials, but we don't worry about criminal as far as mediation goes. You're going to have a lot of backed up dockets. And it's going to take a long time to get your hearing date. And so I think lawyers are going to be looking toward mediation for those cases that they know don't really need to go to court or don't have to go to court. And I think the judges are going to be looking at mediation going, how do I take the pressure off of this docket? And so I do think one of the results of the pandemic is that we may see an uptick in the use of mediation by judges that would not have otherwise used it. So
The
and I
mediator,
think you're right. I think some of the judges, as I mentioned, we're having 30 some odd new judges on the bench.
Yeah.
Many of those judges have been practitioners, boots on the ground, going to mediation on a regular basis. They understand it. They understand how it can be used. It's familiar to them, where a lot of when I started doing this, and even now, a lot of those judges that were on the bench, mediation was not a thing when they were practicing.
Right.
And so I think over time, we're just seeing a shift where it just becomes more normative, I guess, if that makes any sense.
Sure. I think that and the less they're holding court in the courtroom, the more flexible they are with the idea of mediation. And mediation can be used to narrow the issues to have a shorter trial. Like it could be, you don't have to settle the whole matter, but you can settle, A, B, C, and D, and then only have your hearing over E. And that helps the judges do their job and do them quickly. I think that the trend this is just speculation. I have no statistics, but I would think the trend is just going to go up for mediators. Makes judges' jobs easier. Why not? So.
Yeah, absolutely. There are judges now that it's part of their scheduling order. And not all judges use a scheduling order. And so, Lisa, judges' jobs are far more administrative than people who are not familiar with what judges really do behind the scenes. There's a tremendous amount of administrative work that judges are required to do. And they have to manage a docket. I mean, there are a lot of cases that are filed in some areas more than other areas of the state, but their job is to move that docket along. Some judges don't have a strict scheduling order, which sets out when you have your lawsuit, it tells you it's your deadline sheet. It says, this is when this is going to happen on this date. This hearing is going to happen on this date. Depositions have to be done by this date. It just gives you a timeline for everything. Some judges are including mediation in that scheduling order. And they're saying, you're going to mediation before you're going to get your trial date or your hearing date. And it must be done 30 days before your hearing date or 60 days. Some judges don't do it that way. Some judges just ad hoc order mediation. It's not set out in their scheduling order. So judges do it differently. And that's another thing around the state is, that's why I said it depends on where you are, what's normal, kind of what's local practices, and as to how things run. And you really have to figure that out. It's important. The reason it's important to know all this stuff is because when you're mediating, you kind of need to know what the expectations are. And sometimes there are expectations, like with sending in a report to the court. Like some judges, I just talked to a judge, we're preparing for new judge orientation. And so we're putting together a guide for the new judges. And you know, he was like, part of his scheduling order is he wants the report from the mediator by this date. That's what I'm saying. So it's important to understand, if you're going to be doing court-ordered mediations, what the expectation is on the mediator. Like, and you can get that information from the lawyers. I mean, you need to have those conversations. Like, okay, give me the order. Is there anything in the scheduling order that I need to know about? You know, those sort of things. So, yeah, George.
I have a quick question. Can you have, didn't see it in the rules, but can you have, or maybe it was and I missed it, any conversations with the attorneys outside the presence of the people they represent, or are you
Absolutely
outside the client? Okay.
That is a
So if
very
you want to step out and have some of these expectation conversations, you can have those outside the presence of the client or who they're representing.
Yeah, you're gonna have conversations with the lawyers all the time, because a lot of times the lawyers and the mediator will have pre-mediation conversations about, okay, what are the issues in this case? A lot of times lawyers want help. Maybe they have a difficult client. Maybe their client is having a really hard time, like coming to terms with the weaknesses in their case or whatever it is. Or sometimes you just have a high-strung client, or you have a combative client, or whatever it is. And a lot of times lawyers and mediators will have conversations about, these are the issues. This is my client's disposition. Here's where we're having difficulties, wherever it is. So there's a lot of conversation that takes place between the lawyers and the mediators exclusively. And sometimes you'll go out in the hall and meet with them, because you may, as a lawyer, know or believe that what their interpretation of the law may not be accurate. And you certainly don't want to raise that in front of the client. And so you may go out in the hall and say, hey, have you seen that new Court of Appeals case that just came down? And if they haven't, you may want to say, okay, well, why don't we take a few minutes? You go in and take a read and see if, you know, some people are more direct than that. But yeah, so those kind of conversations happen regularly, and there's no prohibition on it.
Okay, thank you.
So, Lisa, in particular, do you have any questions about any of this?
Not really, other than the training that I just went through. You know, of course, most of them were in Missouri.
Right.
But I think, I mean, I don't know, I think we had interaction with maybe 12 to 15 mediators, and they're exclusively doing their mediations virtually. Are you seeing that here in this state as well?
Yeah. Oh,
Okay.
yes. Very quickly, a lot of mediators converted over to doing Zoom mediations. I mean, we're having hearings. Judges are holding hearings by Zoom. Everything has been we've been moving along primarily through the use of Zoom in our court system. And that does include mediation. And as a matter of fact, this semester, when I taught my students, they were required to learn how to use Zoom and conduct a Zoom mediation, because number one, that's how it's being done right now. Number two, it is not going away. When the pandemic is over, Zoom mediation is not going away. So there will be in-person mediation, but there will also be a lot of Zoom mediation.
Okay. The other question that I had was, in my research before even approaching this as a potential career move for myself, you know, I read a lot about it, and there are advantages and disadvantages to attorneys being mediators. There are advantages and disadvantages to, for example, a therapist or a counselor being a mediator. You don't have to have a law degree to be a successful mediator, from my understanding. But I'm wondering, in Arkansas, is it primarily attorneys that are mediators?
Yes. And here's why.
Is that going to be a disadvantage to me if I'm good and develop a reputation? Am I going to be able to get business, or am I just kind of screwed?
Well, I will say this to you. One of our busiest domestic relations mediators in our access and visitation program was a former school teacher. She knew a lot of people in the legal community, and that's what you need to understand. It's not one of the best mediators I have ever seen in my entire life. And this woman mediates not only all over the country, but she actually leaves the country and goes and does stuff, is from a mental health background. She was a licensed social worker who got in and has been mediating forever and ever and ever now. An incredible mediator. She's not a lawyer. But the reality of the market here in Arkansas is that we're talking about court-ordered mediation when it comes to being certified. And most mediation is happening in the context of litigation, whether it's court-ordered or whether it's not court-ordered. It's happening. It's not just two neighbors going, oh, we have a dispute, let's go to mediation. No, it's one neighbor suing the other neighbor, and then either the lawyers say, let's go to mediation, or the judge says you have to go to mediation. That means the consumer of the mediation is really the lawyer. The lawyers are the ones selecting the mediators on behalf of their clients. Lawyers hire other lawyers because lawyers, that's their bent, that's who they know. And in a lot of times, frankly, they want to hire someone that they know knows the ins and outs of that type of case, because they do want some evaluation. They do want help with their client or input from the mediator, because that mediator knows the ins and outs of how these cases work, and they don't have to play catch up with that person, right? But this mediator, she did domestic relations, and she became extremely well versed. She knew everything she needed to know. She wasn't practicing law, but she knew everything about domestic relations cases and child support and all of that sort of stuff, and quadros and everything that the lawyers were talking about. You know, like, she could have an intelligent, educated, informed, and she was really good at working with her clients. And she got a lot of agreements, and lawyers like that. Like, so I hate to say never, but it is a disadvantage I think, to be from a different professional background, because automatically, I mean, lawyers have a tendency to hire other lawyers. That's just the tendency. If you have, you know, you can make connections, if you can get your foot in the door, then you have, and you do a good job, then you have a chance to grow your mediation business. So I never say never. There are people who are not lawyers who find success, particularly in the domestic relations area. It's a lot harder in civil. I never wanted to do personal injury work or wrongful death work. I wouldn't touch that with a 10-foot pole. It's just never been something I wanted to do. I would never get, I mean, as a lawyer. So I don't have any experience in that area of the law. So back in the day, I would never have gotten hired as a mediator to do, you don't see a lot of domestic relations lawyers getting hired to do personal injury cases. What you see is a lot of lawyers who did insurance defense work or plaintiff's work doing those kinds of cases because they understand that system. And it is a system when you're dealing with an insurance company. So that's just the lay of the land and the reality of it. Yes, I agree with you. You don't have to be a lawyer to be a good mediator, but the market here in Arkansas, that's the tendency.
Okay.
So
Lisa, I think, I mean, this is just an opinion in Harrison, especially domestic relations cases need to be mediated. And I think that you would have enough business if you charged an amount that was more affordable than a lawyer who's charging, you know, $250, $300 an hour. I mean, I don't know what, I'm not going to tell you what to charge, but I'm just saying, I think there is a big opportunity here in Harrison, and I'll send you people for sure.
my advice to you as well is get into the access and visitation mediation program, because it's very helpful. If you as the mediator will make $90 an hour, which is below market for most mediators. However, for litigants who would have a problem paying for mediation, they pay based on a sliding scale. They can pay nothing. They can get free mediation, or the most they're going to pay is so if you get on that roster, that's also another way to get your foot in the door and develop. We don't send you, you are selected. You're on the list, and you would be selected by the parties or by their lawyers. But you're in Harrison. If the judges up there are going to start ordering it, and they're aware of this program that can help pay for the parties' mediation, that's how we've seen a lot of mediators get their start. So it can be a really good way to get your foot in the door if you're part of that program.
All right, thank you.
For domestic relations. So any other questions? Because I promised you we were not going to go until noon. Okay. Always, always, always we are available. No question is a stupid question. We would always prefer for people to call and ask rather than, you know, causing themselves more headaches down the road. So if you have a question about anything, always call. Somebody in our office will be happy to help you. And once you get your certification, start paying attention to all the stuff Stephanie Copeland sends out, because you're going to want that CME, which is also, for those of you that have to get CLE, I failed to mention this, you're double dipping. You're getting, yeah, you're getting CLE and CME simultaneously for free. So we don't charge our typically we don't charge our certified mediators to attend the CME programs. So you're getting free CME and CLE, which is just a nice bonus. So.
I did have one more quick question.
Sure.
As far as the application process goes. So like background checks, criminal background checks, DHS, all that kind of stuff. I had all of that because of education, but every time you move to a new place, you have to have the new one. Do I send that to them and have them report to you, or just put the application in my packet and you'll send it off when you're ready to do it, so it's all together nice and neat?
You you send it to us. The state police background check, I can actually run, I'm authorized. And so I actually run that myself.
Okay.
We have to mail off those child maltreatments. And I'm just going to tell you, we can process your application the day we got it, if they would automate their system. But we have to mail it to them.
Yeah.
And then there's no rhyme or reason. Sometimes it takes a week. Sometimes it takes 2 months. That is always the thing that holds us up. Otherwise, we could literally process an application the day it came in the door. But yes, just send those to us, directly to us, and we take it from there. Make sure that it's notarized. Make sure, don't fill it out and then sit on it for 8 months, because then we don't want to use, I don't want to run a background check on something that's 8 months old. I'm real neurotic about the state police background check forms, because I'm the one doing it and there are all these rules you have to comply with. And I just don't want to get sideways with the Arkansas State Police. So we dot our I's and cross our T's, and we have sent those back and said, we need a fresh one. So just don't do it until you're ready to send your packet in, so that it's all, the dates are current. Okay, everyone, it was great. Again, apologize for the issues this morning. Technology is a wonderful thing, but sometimes it makes things go a little more slowly than normal, but we're still getting you out the door before noon. So if you have any
Thank you,
questions,
Jennifer.
give us a call. Yeah.
I said, thank you.
Oh, thank you. Bye,
Have a good
guys.
day.
Thank you so much.